Hi, welcome back to our YouTube channel. I'm your host Abhishek Saxena, and it's an honor to be once again joined by C. Pradeep Modi sir, a practicing chartered accountant with over 36 years of expertise in taxation, corporate law, succession, and financial advisory. Hello sir, how are you today?
I'm fine.
In today's episode, we will be addressing a subject that is becoming increasingly relevant in today's globalized world: cross-border succession, wills, and property laws. Through this discussion, C. Pradeep Modi sir will be simplifying the challenges, opportunities, and practical solutions for individuals and families managing estates across borders. So let's dive to the questions. So my first question to you is, what is the difference between testamentary and intestate succession?
Well, this term we have coined in an earlier discussion also. Again, the testamentary is a document which occurs when the valid will has been made by the person who is no more on this earth.
Okay.
And interstate documents will happen when there is no will. That is, without will, the properties and other things will go according to the law of the countries. So this is the difference when there is a legal piece of paper is available on which the deceased person write his wishes, in whose favor the properties will be assigned in what proportion. That is called a testamentary.
Okay.
And when without will, it is called a intestate.
Okay. So in a cross-border scenario, which law governs the succession of immovable property?
See, basically, when the property is a immovable nature, because there are two types of property. One is movable and other is a immovable property.
Exactly.
And when there is a immovable properties, the properties where it is located, the law of that country will be applied.
Okay.
So very important that where the property is located, immovable property is located, that country's law will prevail upon in case of a immovable property. In case of a movable properties, the domicile is very important.
Okay. Okay. So my next question is, which law governs the succession of movable property in a cross-border context?
In a cross-border context, let us say that somebody who is having a permanent kind of residing in USA or UK,
Yes.
or in UAE, and he has also certain properties in India, certain properties in UK, certain properties in USA. All these are the movable assets like the bank balance, the investments, the life insurance policies, and all these. These are all called movable properties. So in this case, the law will be applied to a respective assets only the person where he is a domiciled.
Okay.
So law of the domicile will be applicable in case of immobile properties. In case of immobile properties, where the properties are lying.
Yes.
So this is the main difference. Here the importance is given to a person's domicile. In case of immobile properties, the importance is given to a locations where immobile properties are situated.
Okay. Okay, sir. Sir, what is the legal definition of a domicile?
See, domicile is a person where normally he is attached with all his interests. Merely doing a business at one place is not sufficient.
Okay.
But his family interest, his life interest is been attached to a particular place where he is habituated to stay, where he is enjoying his life. That is the code where it is a said domicile. So domicile is the person's permanent residence, or rather than habitual residence or habitual abode, along with his all personal interests are more attached to that specific locations, and that location is attached to a one country where geographically it is attached. So that is called a domicile.
So can a person have more than one domicile?
Answer is no. It cannot be having a more than one domicile, because a person can be attached to a one and one only places. He cannot have a more than one domicile. He can make a change, he can make a shift in domicile.
Okay.
He can say later on, for example, suppose he is a domicile currently in UK and he migrated to India, for example, and all other interests, personal interests, along with the businesses, along with the family, along with all other interests, may be shifted to India, then that domicile can be changed. Domicile cannot be a permanent, it can be changed, but a person cannot have a two domicile.
Okay. So what is the domicile of origin?
Domicile of the origin normally is attached to a person where he normally resides.
Okay.
But in case of the minor child, or the person who is not in a capacity to understand his contractual obligations,
Yes.
then in that case the domicile in origin will be attached to a father.
Okay.
But for a legitimate child. But for illegitimate child, the domicile of origin is attached to a mother. So this is the difference. Normally when person take a birth and father where he resides, that will be the domicile of that person. But when his father is migrated to some other places, his domicile is also going to be changed. But when person become a major, then according to his wish, he may have taken a birth in, let us say, South Africa, but he settled in a UK or he settled in Mauritius, then domicile can be changed as a major person and that can be relocated.
Okay, sir. How can a person acquire a new domicile?
By making a migration to one place to another place, by shifting his business interest and family interest, he can migrate a domicile from country X to country Y.
Okay. Does a woman's domicile change upon marriage?
Yes, 100%. 100%. Normally, because her domicile is attached to her husband. So wherever her husband resides, in that country now become a domicile for the wife.
Okay. So do the domicile provisions of Indian Succession Act 1925 ISA apply to all the communities?
Good question. Normally people have understanding that the Indian Succession Act is applicable to those who are staying in India. But really it is not so the case. Because it is applicable to only the Christians, Jews and Parsis. These are the three communities where the ISA is applicable, Indian Succession Act. In case of the Jain, Sikh, Hindus, Muslims, they have their own personal laws. And therefore the Succession Act, Indian Succession Act is not applicable. Their respective personal law will be applicable. Like in case of a Hindu Succession Act is applicable. In case of a Muslim, it is a Mohammedan Succession Act will be applicable. So ISA is not applicable in all the cases.
What are the forced heirship rules?
Very, very interesting questions you have asked. That the forced heirship rule is very, very typical as far as the countries which are following the civil laws. Because in case of a civil laws, very important part is that you have a very limited freedom to make a selection of your beneficiaries for the purpose of succession of your properties. Very limited. Because you have to go by the law which is written in that country, and that is called a civil law. So for example, in case of a France, in case of a Germany, in case of a Switzerland, these are the countries where the civil laws are prevailed upon, and therefore the forced heirship is going to be imposed on the person who left the estate behind him. While in case of India, we have the common laws. Common laws means we have a full freedom. So we are writing a will 100% as per the wish of a deceased person. It will be distributed the estate to the person to whose name is been written. So this is the difference, and therefore the forced heirship rule is not applicable in India because India is following the common law system.
Thank you so much, sir, for answering all these questions. So that's all for our first episode of Cross-Border Succession, Wills and Property Laws. Thank you so much for watching. Stay tuned for second episode. Thank you.